sort of protect themselves against that, the U.S. has focused very much on, again, the process for if there's a low-level presence incident. So this requires that the receiving country that might receive the biotech product that's not fully approved, that really should not be in their market, instead of just banning it outright, they're supposed to go through the steps of this process of reviewing the science together and kind of nudging the receiving country into kind of a risk assessment instead of just saying, no, there's a problem, this stays out, rather engaging with the U.S. through various committees and bilateral discussions, at kind of a technical level to see if there isn't some way to almost do a kind of backdoor approval. So that is, it's only time will tell how that works out, but that is kind of a nose under the tent way to get at better engagement and pushing other countries on the approval process. So I think with that.
Thank you. Yeah, that's a great introduction and great background of a lot of things that aren't being talked about and that many people don't know. So thank you for that, Jessica.
You're welcome. So I guess we'll have questions at the end, perhaps?
Yes, we will. So, and then our next speaker is Juan Carlos Partida from Mexico City, and he is experienced in trade remedies, investigations, customs law, NAFTA, WTO, and ad law. He focuses his practice on international trade remedies and customs, regulatory issues, and anti-money laundering. And Juan has also worked in the United States at King & Spalding in D.C., so he used to be a neighbor of Jessica's, and he worked in trade remedy cases. And the interesting thing to me is, in particular about Juan Carlos's background, is that he's designated as a panelist by both Mexican and U.S. governments for dispute resolution pursuant to Chapter 19 of NAFTA. And so, Juan Carlos, welcome.
Thank you, Susan. Thank you for inviting me. Good morning to everybody. I'm going to try to talk a little bit in the beginning about Mexico's objectives at first when negotiating this NAFTA 2.0. I still like to call this agreement NAFTA or NAFTA 2.0 instead of USMCA, TMEC, which is the name that has been given by the next administration here in Mexico, or USMCA, which I've heard that name as well, but I don't like any of those names, so I'll just refer to it either as a NAFTA or USMCA, which is easier. I'm going to start with the objectives that were pursued by Mexico in the negotiations of Chapter 3 of dealing with agriculture. And then I will talk about what's going on in Mexico with GMOs and specifically with the corn issue in Mexico, which is probably the most mediatic and probably the most heard of issue about GMOs in Mexico. Well, first, Mexico also viewed this, the negotiation, the conclusion of the negotiation of Chapter 3 and overall of NAFTA as a success. I don't know whether it is really a success for the Mexican government or not, overall the negotiations of NAFTA, but at least Chapter 3 agriculture, Mexico's objectives were met. The first objective was to maintain free trade for agricultural products originating in Mexico. And in these negotiations, there were no changes at all in free trade access to agricultural products. Thus, this objective was achieved. The second main objective, was to reach a compromise to eliminate export subsidies on agricultural products, and this objective was also met now in Article 3.4 of the new NAFTA 2.0, which requires that no party shall adopt or maintain any export subsidy on agricultural products that is destined to, or that are destined to the territory of another party. The third objective was to determine and place a clear and transparent mechanisms to allow the communication, cooperation, and collaboration between the parties to discuss agricultural products. Again, this objective was also met and was achieved through the establishment of a Committee on Agricultural Trade, which should be meeting every so often and then communicating to the Trade Committee that was also set up in the agreement. And the fourth main objective was, and perhaps this was not to be included in this chapter, but was dealing with agricultural issues, was not to allow anti-dumping investigation for seasonal products. And this was perhaps the only issue that dealt with the agricultural sector that could have had an impact on the ultimate result of the negotiations. U.S. trade negotiators proposed at some point to allow seasonal or perishable product producers to bring cases against foreign importers, effectively creating an end run around the legal requirement for a trade remedy action to be on behalf of an entire industry, which is the standard for trade remedy cases. The primary push for this seasonal exemption was coming mainly from the southeastern produce growers in the U.S., especially the tomato producers in Florida, who are or have been concerned for a long time with competition from Mexico. This provision would have allowed agricultural producers by states or regions within the U.S. of a seasonal commodity to bring cases that would have analyzed based on their experience alone, regardless of whether producers of the same product in other states had the same concerns or suffered any injury. This issue of the seasonal products anti-dumping measures was a deal breaker for Mexico, and fortunately, at the end of the negotiations, the proposal was withdrawn by the U.S. negotiators. So the whole sector dealing with agriculture was finalized and successfully negotiated. What is interesting is that bioagricultural technology was never an objective of the Mexican government nor an issue for the negotiations. This is perhaps because, as it has been mentioned previously by Jessica, the U.S., Canada, and Mexico are already aligned on biotechnology policy, and that is on the importance of agricultural innovation and to facilitate genetically modified organisms trade. So basically, there was no concern by the Mexican government for negotiating these specific provisions within the agreement. And I will not touch upon the provisions that were added to this NAFTA 2.0 or USMCA regarding biotechnology, because Jessica has already discussed them, and as she says, is more a process of approval of biotech by the parties and acceptance by the parties of the biotechnology authorizations by the other parties. However, and despite the fact that bioagricultural technology was not an objective nor a concern for the Mexican government in the negotiations, the debate within Mexico around nutrition, biotechnology, and health acquire interesting notes when we talk about genetically modified corn. So let me just throw some points regarding this issue in Mexico, and we can discuss them at more length in questions and answers. And let me start by saying that the use of genetically modified organisms began in Mexico some 30 years ago. In 1998, the Mexican government authorized the first trial or experimental planting of genetically modified tomato in the northern part of Mexico. I believe it was authorized for Campbell's, if I'm not wrong. In 1996, the Mexican government issued the first official standard to regulate imports and the liberation of GMOs in Mexico. In 1999, the government instituted or created the Intersecretarial Biosecurity Commission for the Genetically Modified Organisms The acronym for this entity, governmental entity, is CBioGem or CBioGem, and was created immediately, and it immediately started being in charge of establishing the government policies with respect to the safe use of GMOs. The first trials in situ for the growing of genetically engineered or genetically modified corn began in 1993 under strict control of the government. And then from 1996 to 1998, the requests for authorization of in situ trials increased, and then the government suspended from 1999 until 2005 the experimental and commercial growing of genetically modified corn. Due to this suspension of the trials for corn during these years, over 90% of the designated areas for experimental crops was dedicated to other products such as cotton, squash, canola, chile, potato, pineapple, soybean, and tomato, and other products. And it was not until 2005 when Mexico enacted its law for biosecurity of genetically modified organisms, and such law allows for the advance of GMOs in Mexico. The law regulates the activities for the confined use and liberation of GMOs to the environment, its commercialization or sale in the market, imports and exports. As of that year, that same year, 2005, there was a boom in the approval of permits for liberation of GMOs as a result of the enactment of this law. However, in 2003, and this was some years after the enactment, but it was a slow process. In 2003, due to the imminent authorization by the government of more than 70 commercial permits to plant genetically modified corn, a civil class action was filed by a group of scientists, researchers, environmentalists, and consumers, asking the tribunal, Mexican tribunals, to declare that the limits and restrictions that were established in the law are inefficient, and there is a scientific evidence of transgenetic contamination of native corn in certain states in Mexico. So this civil class action was actually filed to protect the over 50 native corn species that we have in Mexico. And the purpose of the class action is actually for the tribunals to declare that the liberation or growing of genetically modified corn affects the human right to the biological diversity of the native corn, and thus prohibit all permits that are requested. Along with this suit that was filed in 2013 as a civil class action again, an injunction was also requested and was granted first by the district judge and then eventually upheld by the circuit court. The judge ordered the federal government to suspend any activities with the purpose of granting permits for the liberation and growing of genetically modified corn. This class action is now more than 5 years old, and the injunction granted has survived multiple appeals filed by private companies and also by the Mexican government. Now, will the USMCA biotechnology provisions have an impact on the case and the suspension of the granting of permits to commercially grow GE corn? I don't think so. In my opinion, the class action and suspension deals with the issuance of an authorization for a genetically modified product to be sold in the internal market, and that is, in my opinion, a prerogative of each party, of each country. And the non-authorization of genetically modified organisms to be produced in Mexico does not affect trade, which is one of the objectives of NAFTA. In fact, trade, that is imports, including of genetically modified corn, of authorized GMOs, is and has been permitted so long as the previous authorization is issued. So we even though the Mexican government or the Mexican courts still ban the growing of genetically modified corn in Mexico for consumption, for human consumption. There are imports being made into Mexico of genetically modified corn, which is mainly directed at for feeding cattle, but also there's some of those corns that are directed to other industries such as food, I don't know, industrialized food. So there is some importation of corn that is genetically modified for human consumption, but still the ban for the growing in Mexico of genetically modified corn is still in place. So I guess I will just end here, so we can have some questions at the end.
That's great. Thank you very much, Juan Carlos, for that, and for clarifying quite a few things for me. And I'll look forward to further discussion on these issues. And next, we're going to turn to our policy people. First, Steve, do you want to unmute yourself?
Sorry about that.
Oh, there we go, Steve. Steve, is your last name pronounced Suppan? That's how I've always pronounced it in my head, but I've never said it out loud, so I just realized that.
Phonetically, it should be Suppan. That's how it's pronounced in Austria, but there's a long story behind that.
Okay. Welcome to Steve Suppan, who is a senior analyst at IATP, and he's been there since NAFTA was enacted or became effective. And he works on U.S. ag trade and food safety policy, and he explains it to foreign governments and NGOs and works in particular with farming organizations. Steve's traveled the globe, 35 countries, and also including Mexico. And he's represented his organization at meetings of Codex Alimentarius Commission, UN, Commission on Sustainable Development, and UN Food and Agriculture Organization. And he's done some very significant research in a global report, and we couldn't be more thrilled to welcome Steve. And if you want to start, Steve, I will pull up your PowerPoint.
Okay. Well, thank you very much, Sue, and thanks for this invitation. I'm going to begin talking about the Section A in the new NAFTA of the agricultural chapter, and that chapter has a kind of overall chapeau. I don't see the slides yet, so I guess I'm going to talk from the paper version of the slides that I have. One of the most important and uncommented features of this section is that it is governed by the overall provisions of the agricultural chapter, and that means that the chapter applies to all agricultural goods listed in the Customs Union Harmonized System of product codes. There we go. And so that includes live animals and fish. Apparently fish is not yet included in the World Customs Union Harmonized System, and so they've added it to it. What the Section A allows is trade of ag biotech products that do not have commercial authorizations. It requires importing countries to import an incidence of low-level presence occurrence of ag tech products that have not been approved in the importing country. And I'm going to talk about the LLPO incidence in a bit of length. Unlike the Trans-Pacific Partnership Agreement, there's no provision to negotiate LLPO quantitative thresholds, occurrence frequency, testing or sampling methods, and related labeling measures. There's a kind of vague reference to international standards regarding testing and sampling, but there's really nothing for testing and sampling of genome-edited agricultural products. The legal burden is reversed, so it's the importing country that has to expedite the imports in low-level presence incidents. The exporting country has no legal responsibility. So, for example, the U.S. Grain Inspection Service has no legal responsibility to prevent the inclusion of unapproved varieties in export consignments. The testing and industry studies that are used in U.S. Reviews of GMO applications for commercialization are protected as confidential business information. This doesn't happen within the agriculture chapter, but within the chapter on sanitary and phytosanitary standards covering food safety, plant health, and animal welfare. And there's a final point that I didn't put in here that I probably should have added, and that is that the new NAFTA requires all parties to sign the union on the agreement of the union on protection of new plant varieties in the 1991 version, which restricts use of indigenous plant breeding that could violate patent claims by biotech product developers. Next slide, please. So I just want to indicate that there are currently low-level presence thresholds and agreements on labeling. There's also agreements on testing and sampling methods. This is sort of indicative. The European Union currently allows only a 0.9% threshold for unapproved varieties. The U.S. Grain Export Council in the past has demanded a 10% threshold. And there's no indication of how frequent that threshold can be crossed before the whole notion of adventitious is essentially violated. Other countries have corresponding labeling requirements. Of course, the United States does not label products of genetic engineering of any variety. Next slide, please. It's important to realize how little regulatory infrastructure the United States has to enforce low-level presence occurrences. This is a staff directory for the U.S. Grain Inspection Service. It has only 4 compliance officers. 1 position is vacant. And those 4 compliance officers not only would have to cover the 13 ports of entry into the United States, assuming that that the new NAFTA becomes the model for all future trade agreements, which is what the United States intends. But it simply does not have the technical staff to do the sampling and testing methods currently to comply with the agreement. Next slide, please. So it's also important to understand that the United States does not regulate in the sense of have mandatory rules and mandatory risk assessment of products derived from genetic engineering. This is a typical letter. This is the letter that's been going out for the last 22 years now. And this is from the Food and Drug Administration to Monsanto, explaining why it will not approve or regulate the Dicamba resistant corn. And I'm just going to quote one sentence here to give you an understanding of what is entailed here in the FDA review. Quote, based on the safety and nutritional assessment Monsanto has conducted, it is our understanding that Monsanto has concluded that food and feed from MON 87419 corn are not materially different in safety, composition, other relevant parameters from corn derived in feed currently on the market, and that the genetically engineered MON 87419 corn does not raise issues that would require pre-market review or approval by FDA. So there are no pre-market safety assessments done. There's no formal risk assessment or approval. And it's important to understand that Monsanto gets to choose what evidence it wishes to present to the FDA for FDA officials to review. And then finally, FDA reminds Monsanto that it is required to obtain other clearances from other U.S. agencies, including the Environmental Protection Agency and the U.S. Department of Agriculture. Next slide, please. So this is what Dicamba does to soy plants that are not engineered to resist Dicamba. Over 1 million acres of Dicamba non-resistant soy plus horticulture plants have been damaged by Dicamba. Scientists warn that that Dicamba was far too volatile to be used in agriculture, but the Environmental Protection Agency approved it anyway. And it's important to understand that most of the genome edited plants will be stacked varieties, and so they will be engineered for more than one trait, and one of those traits will almost certainly be pesticide or herbicide resistance. Next slide, please. So this is just a short table of some of the products that have been modified without any U.S. regulation. These are at the point where they can now be released commercially. None of them have been, to my mind. Among those, I think maybe the white mushroom has been. But the important thing here to realize, again, is that there is no mandatory regulation. Again, the company gets to choose what it wishes to present as evidence and what it wishes to withhold. Next slide, please.
Steve? Steve, you're muted. There you go.
Okay, I don't know okay. How. Okay. So, one of the reasons it's important to understand the weaknesses, of course, in a voluntary system of consultation with U.S. agencies, is that despite the claims of precision editing, there are hundreds of off-target traits that occur, and this is partially due to the complexity of genomes. So, for example, in the case of the maize or the corn genome, only about 30% of the edits are on target. So they produce the traits that are intended by the product developer. And this is a major issue because some of these mutations are benign. Some of these mutations may be beneficial, although they're not understood, and some could be very harmful. And there's a whole science of biosafety that investigates this issue. Next slide, please. So when we attempt to get the correspondence between the agencies and the applicants for commercialization through the Freedom of Information Act, these applications come back. About 80% to 90% of them are redacted. And so there's no way to know what kind of information has been presented for peer review. The agencies maintain a list of some of the studies that they use in reviewing the applications, but these lists are not kept up to date. So this is a very poor, scientifically weak system, made weaker by the Trump administration in terms of capacity for peer review of these applications. Next slide, please. Just very quickly, the biotechnology industry in Mexico follows the Biotechnology Innovation Organization, the American Farm Bureau, and so on and so forth. And in this particular article, the so-called protections that are offered in regulation are linked to Section A of the new NAFTA. Next slide, please. Farm organizations throughout Mexico are calling for a national consultation about the Spanish version of the new NAFTA because officially there is no translation that has been presented to the Mexican Senate. Next slide, please. And so as a result, there is a broad civil society coalition which is saying we cannot have a vote in the Mexican Senate on November 30th, or we cannot have President Peña Nieto signing a document that many if not most senators in Mexico cannot read. It's a long and complicated text. I've only read about 60 pages, and I can attest to just how difficult the reading is in many instances. So thank you very much for the opportunity to make these views, share these views with you.
Thank you, Steve. And that was a very, very nice combination of what the prior two speakers, you pulled together what aspects of the prior two speakers. So thank you for that. And now I am delighted to have a technical issue. There we go. I'm delighted to introduce Timothy Wise, our next and final speaker. He's with the Small Planet Institute as a senior researcher, and he's also a research fellow at Tufts University in their globalization program. He's an economic journalist and international development practitioner, and he covers farm policies, trade, agricultural development, biodiversity, food prices, biofuels, and Mexico's maize economy, which is what we're talking about today, so it couldn't be more appropriate. And Tim has a new book coming out in February called Eating Tomorrow, Agribusiness, Family Farmers, and the Battle for the Future of Food. So you'll want to be on the lookout for that. Welcome, Tim.
Thank you very much. It's a pleasure to be here. Thank you for inviting me, and I really appreciate the detailed background given by the previous three speakers. I think I'm going to take that as giving me license to be a little less detailed and a little more perhaps contextual, looking at the issues that are on the table for Mexico right now as it as a new government comes into power, and what the issues are that are particularly relevant in relation to agriculture and how those might be affected by the new NAFTA. As I think most people know, the Andrés Manuel López Obrador from the new Morena party, National Regeneration Movement Party, swept into office in July, and with his party taking complete control of both the Senate, the House, and with a very large mandate. It goes less commented that a significant part of that mandate came from rural Mexicans who voted in unprecedented numbers for a party outside of the traditional mainstream parties in Mexico. Some 8 million votes came from rural areas, and so there's a reason for that. The reason is that López Obrador, in his history and in his actual campaign, made very specific promises to small-scale Mexican farmers and the farm sector in general to, quote unquote, rescue Mexican agriculture. And what he was intending to rescue Mexican agriculture from was NAFTA and what Mexican farmers consider a free trade nightmare that they've been living in the 24 years that NAFTA has been in effect. So the objectives of the Mexican farm movement, newly united in what's called the Plan de Ayala movement, had their own objectives for a renegotiation of NAFTA. Renegotiating NAFTA has been a demand of the Mexican farm movement for a long time. I appreciate Juan Carlos laying out the Peña Nieto government's objectives in renegotiating NAFTA. Those objectives do not include in any way the objectives of the Mexican farm movement. The Mexican farm movement has demanded for a long time that agriculture in general and maize in particular be pulled out of NAFTA so that Mexican farmers would not be subjected to the importation of not just of genetically modified maize and other crops from the United States, although that is a concern, but more importantly, perhaps, of underpriced, subsidized, dumped U.S. commodities, which have been coming into Mexico without any restrictions since NAFTA was implemented, and that's had really serious implications for small-scale farmers, in particular maize farmers in general. After NAFTA, they saw a 400% increase in U.S. imports. Those imports were coming in for many of those years at prices 19% below the cost of production in the United States, one definition of dumping. And they saw a remarkable 66% decline in prices for their products, for their own maize in the marketplace as the international competition forced down prices. So I say all that by way of background on what López Obrador's new agricultural policies are promising to do, and then I'll look briefly at what that means for what the new NAFTA means for the prospects of those policies. Unfortunately, one of the things that the new NAFTA does not do, and that the Mexican farm movement would have really probably most wanted a new NAFTA to do, is allow for the restriction of U.S. exports at below production costs to Mexico, allow the Mexican government to protect key sectors, key food producing sectors in particular, and maize far and away the highest priority among them. That was obviously, as Juan Carlos laid out, not an objective. The objective of the Peña Nieto government was to maintain free trade. That's not consistent with what the farm movement wanted. López Obrador clearly has made his peace with not wanting to upset the apple cart on NAFTA, and so he's not challenging that provision. But the other provisions that are relevant, that I think are really important to keep in mind, are that he has made a commitment consistent with the farm movement demands to regenerate Mexican agriculture, and to do so by favoring food self-sufficiency and policies to promote it. That includes paying supported prices to small-scale producers, with a particular emphasis on producers of native maize, to create incentives for the production and consumption of native maize varieties rather than either hybrid maize grown in Mexico, mostly largely in the north, in the more industrialized sections of Mexico, and imported. So NAFTA, the new NAFTA, has some provisions that could make that more difficult. It has advisory provisions, not binding provisions, saying that governments should use policies that are the least trade distorting, and paying support prices definitely distorts the market. So they can be interpreted as trade distorting. I don't think that will prevent or slow López Obrador's government in pursuing those policies at present, but it could open Mexico to some challenges. That's something to watch. A second, that there were some fears in the negotiations that the agreement would specifically limit Mexico's right to label unsafe or unhealthy products, food products, in the marketplace. This is particularly of concern for Mexico because it has a huge obesity crisis. The leading nation took the lead from the United States in childhood obesity. It's considered very much a NAFTA problem in the sense that U.S.-style food consumption patterns have taken over in Mexico, and it's a major public health concern. Other countries have demonstrated that labeling clear labeling of and taxes on food, on unhealthy food products, can have a major impact on that kind of problem, and the government wants and needs the right to maintain that. The new NAFTA did not include an explicit prohibition on that kind of language, although there are definitely a series of measures related related to the kinds of standards that the government should use in imposing such standards. So there could be hurdles there. Lastly, the big issue in Mexico right now, as Juan Carlos pointed out, is the battle over the planting of GM maize. And actually not just GM maize, GM soybeans too, have been in 2017 there was a suspension of planting of GM soy because bees feeding on the pollen had contaminated the organic honey that was being exported from Campeche, and so again, precautionary measures were taken by the courts to suspend that planting. The moratorium, or the injunction that has prevented the seed companies from continuing their experimental planting intended to expand to full commercial planting in a 10% of the northern part of the country considered not to be by law a center of origin for maize, is still in effect. And those seed companies, I interviewed 6 officials from Monsanto in 2014, and what was clear interviewing them is that their goal isn't just to grow yellow maize, GM yellow maize for animal consumption. It's to grow GM white maize and yellow maize for human consumption, to enter the tortilla chain, and to bring and to do so not just in that 10% of the country in the north, but in the main industrial white corn producing area of Sinaloa and other parts of Mexico. So I say all that because I think the current government, the incoming government, has announced that it has a plan to restrict or perhaps ban the cultivation of GM crops, to withdraw the permits that the Department of Agriculture has granted, even though they've been held up by the injunction. And I think the big question in Mexico is whether the new NAFTA restricts in any way the ability of the Mexican government to regulate in that way. I appreciate Juan Carlos pointing out that he doesn't believe it does restrict, that, if I understood right, restrict the Mexican government's ability to do that. That would be my read as well. And I think that's particularly important because that is what the Mexican government has said it intends to do. And if it goes ahead and does that, that will settle, for now at least, a really big question that relates to GM corn in Mexico. I'll stop there.
Great, thank you. Yeah, that is one of the questions that's been really on my mind, is what the intersection is between NAFTA and the local government. So now we are moving to the questions and answers. Thanks to all our panelists who have done a great job of presenting. I'm going to unmute all panelists. And so if there are any questions, now is your time to ask. And give me just a second here to get through my unmuting. So if you want to there you go, mute yourself for any reason, you can do so. One more. Jessica. Okay, so If anyone has questions, you can type them into the chat bar on the side of your screen. And if you don't, I have plenty of questions. There's feedback from somebody. I don't know who that is. Maybe just mute yourself unless you're talking. But so I think this has been covered, but I just want to know, like, talk about how much more we're expecting for U.S. biotech products flowing into Mexico and Canada because of the new provisions.
So this is Jessica. I can answer that, and the others can chime in, I'm sure, too. But not a big change, you know. As we all pointed out, the new provisions of the new NAFTA or USMCA are procedural and sort of to have a longer term, probably standards type setting, harmonization type impact as far as between the three countries. So I think the answer is that you wouldn't see too much change, but I'll let maybe Juan Carlos and some others give their point of view as well.
This Juan Carlos, no, I agree with you totally.
Okay, well, that's not too lively.
Yeah.
I'm teasing.
But this is Steve, and I'll be getting. I have to get off for another call, unfortunately, in a couple of minutes. So I think what the United States hopes to do with this agreement is to prepare the legal pathway for an increase in horticulture products at first, and then subsequently genome-edited animal agriculture products and fish products. And there are, these commercialization approvals that have been granted, but the products have not yet entered into Congress. I think part of the delay in commercialization is a legal fight over the USDA's proposed labeling scheme, or it's probably an unconstitutional labeling scheme, and so that's going to be a fight that will take a while to resolve in the courts. That last question I think is very interesting. How does this impact small farmers in the United States? Well, small-scale farmers in the United States are basically getting wiped out because their production is receiving prices that below the cost of production in almost all agricultural commodities, and it's even impacting the premium that organic culture has received during the last 10 years of its growth. And so I think there's, and then this question about technology changing so quickly. One thing about the CRISPR technology, which has been sort of given pride of place in the genome editing techniques, is that scientists are discovering that there's already resistance developing to the CRISPR editing. And so I would imagine that we're going to be seeing more scientific literature about that. I'm afraid I'm going to have to hang up now and go to my other call.
Thank you very much.
So much. All right.
Pleasure.
Yes, thank you so much. Have a good webinar.
All right. So, yeah, so that jumping to that technology question, and that's the thing. I mean, the CRISPR technology came on the scene so fast, and it doesn't seem like there's really an adequate way to regulate it, and especially because it has so many unintended consequences. And so how would we deal with that in under the new NAFTA? Is there anything different?
Well, this is Tim. I think in Mexico, again, this is what I've been told. I don't think obviously the new Congress was seated in early September. The new president doesn't take office until December 1st. But the indications that I've gotten from people in his government are that are mixed. But the indications are that if they're going to limit the cultivation of GM crops, they will also limit the cultivation of the new technologies, treating them as GM crops, as the European Union has chosen to do.
And
that's my sense.
Okay, and that doesn't conflict with the treaty.
Right, because the treaty is mainly about trade in those products rather than than planting.
Mm-hmm. That makes sense. And I think we've talked about the position of the incoming administration, Juan Carlos, and then the impact on small farmers. We touched on, Tim. And also, the other question I had was, this is the permits to grow GE corn in Mexico.
Yeah.
So,
can I just add something?
Yes,
about,
I would love to have your contribution. Yes.
Yeah, the position of the incoming administration regarding GMOs. I heard Tim, what he said, and I agree with him that's what their intent is of doing. To at least that's what they have said. They want to ban the planting of GMO seeds in Mexico. However, as with this administration has been, at least prior to their actually inauguration or entering into government, everything is, in my point of view, is that everything is up in the air. It's a lot of uncertainty, and one of the reasons is that, for example, there was a question back in 2007 when he was in the campaign. Whether he would, it was a very short question, and I don't know if he understood it, but there was a question whether he was for and against GMOs in Mexico, and his response was, and this is, I think, valid for everything he says, it's whatever is best for the nation and for its people. So what that means is, I don't know what he's going to do now. Some of his officials that have been designated as, for example, the Minister of Agriculture and also his Chief of Staff of the Presidency, both of them have backgrounds of supporting the GMOs in Mexico. So there has been a lot of questioning about designating them as part of the cabinet. Although the next, Victor Villalobos, who's the next Minister of Agriculture, has said publicly that the priority is self-sufficiency in Mexico, and that no GMO seeds would be used by the next government. But there's still a lot of confusion, or at least a lot of organizations in Mexico don't believe him, because he was one of the main supporters of GMOs in Mexico some years ago. I don't know. Again, it's all uncertainty. That's my point of view.
Mm-hmm. Thank you.
This is Tim.
Go ahead.
This is Tim. I would agree with that there is plenty of uncertainty still, and but what's interesting, I mean, that's one of the reasons that when I talked in September with people who are part of the class action lawsuit that has gotten the injunction on maize planting, that their intent to go on with their lawsuit, and the reason they want to do that is that the basis for their lawsuit, interestingly, is not claiming human health impacts, but claiming the human right to a clean environment, and a clean environment that includes protection of agricultural biodiversity as a patrimony of Mexico. That was an interesting choice they made. They've won that. One of the judges actually that ruled on one of the appeals said Mexico, it grants the right to a clean environment as the present right of future generations. And so if their intent to go ahead with that, because they very much want to establish that it is a constitutional right. The protection of biodiversity would therefore be recognized as a constitutional right, and that would make it exceed the authority of any trade agreement. So it couldn't be so easily undone. The other interesting thing that we're talking about is that the need for precautionary measures in Mexico is, I feel like we can often gloss it over outside of Mexico. It's illegal to plant GM crops, GM maize in Mexico. Imports, as everyone says, are mainly destined for the animal sector and for industry. But recent studies have found that the presence of GM maize in 90% of the tortillas sold in supermarkets. A recent study of Maseca showed that some 90% of Maseca samples, the main tortilla maize flour and tortilla producer in Mexico, it showed the presence of GM crops and GM traits, and also of glyphosate, Roundup, in their products. So the food safety issue is also front and center for Mexico. And one of the things that I know people are talking about is revisiting the 2005 biosafety law, which in Mexico was denounced as the Monsanto law by people in the farm movement, because it granted it was too little. As they put it, it wasn't a biosafety law; it was a biotechnology opening, and that's the opening that has allowed the granting of permits for GM maize cultivation. They want to close that opening by revising the biosafety law. One of the scientists who is the most prominent in studying the contamination of food with GM, the presence of GM crops, is Elena Buya Alvarez, who is the designate to be the head of the science agency under López Obrador. So there may really be a possibility of the Mexican government shifting the regulatory framework within Mexico on biosafety and biotechnology, and that's something to watch.
Thank you for that. We do have a question that came in, and I also want to say that Tim gave me a nice segue to next month's What's for Lunch panel, because we're talking about GMOs and safety and health, and how does that impact? I mean, does that impose an obligation on the governments to take that into consideration when they're negotiating? So we'll fill you in on that in just a couple minutes. We have a couple more minutes here, and a question. I'm a social science researcher who works on CRISPR Cas9. It's very clear that there is an effort to carve gene-edited crops away from GMOs in the science and, by extension, regulatory literature. The EU courts, as panelists have said, have not fallen for this, but I wonder, given the extent of alignments of U.S. and Mexican governments, if there might be a strong push for CRISPR edited crops under the argument that they are non-GMO. Interesting question. Who wants to tackle that? Nobody.
Again, this is Tim. I'll only repeat what I may have just said, which is that at least among the people I spoke to who were coming into the new Mexican government, there was some sense that they were aware of that contradiction, and that threat, and that any new regulations, restrictions, banning of GMOs in terms of planting would need to be would encompass CRISPR as well, the new technologies.
Thank you.
That's again, NAFTA as an agreement relates mainly to trade in those products, and I think it can be assumed that if they're being produced in the United States, they'll be imported into Mexico, and people tortillas, and that's a great concern. To get to perhaps a good plug for the name of your session, Susan. What's for lunch?
Yes, exactly. And that's what I really want to address is ultimately because so few of us think about how what we eat and what's on our plates is so closely linked to uh, trade policy, and it's an important issue for everybody to pay attention to. So I think you've just answered that what it affects what's on our plates for lunch in terms of in Mexico, it would be contaminated tortillas, and in the U.S., I guess, the benefit is that we are able to import more variety of fruits and vegetables all year round. But do either of you have a comment on that, Tim or Juan Carlos?
No, this Juan Carlos. No, I don't. Sorry.
Okay, that's okay. So,
No,
go ahead.
I would only say, perhaps by way of closing, I know you need to wrap up, but that I do think the question of what's for lunch, the real answer is we don't know. We don't know in the United States. They don't know in Mexico. This revelation that the Mexicans were consuming genetically modified traits and glyphosate in 80 to 90% of their tortillas, and in the flour and that they're buying in the markets, it is news to them. They go unregulated, they go unlabeled, and I think there's a real consumer campaign now to clean up the tortilla chain and to return Mexico to a much healthier tradition of eating what they call nixtamalized maize tortillas made from native maize varieties and in the traditional way using lime that produces a much more nutritious and much less damaging product. So there's some growing consciousness of that as well in Mexico, and I expect under the new government that will be even more prominent.
Well, that's the good news. Thank you for ending on that positive note, Tim, and thanks to all of our panelists, and thanks to you, the participating audience. I hope you'll join us in December, where we're talking about GMO agriculture and health, December 13th, same time, same station. And we want to talk about who's winning the tug of war on safety of GMOs and the chemicals. There was a recent case in California in which the jury awarded multi-millions of dollars in damages to a gentleman by the name of Mr. Johnson. And the jury found that Monsanto suppressed evidence of the harm caused by the chemicals, the glyphosate that Tim mentioned. And so what does that mean for the future of trade policy? Is it significant enough that the government has an obligation to protect its citizens? So always interesting, always lively. Thank you all, and we will see you again next month.
Thanks, Susan.
Thank you.
Thanks, Susan.
Yep, thank you.